Okay. Okay, so I will call the CJCC Executive and Operations Committee meeting for July 24th of 2024 to order. Listed, looks like everyone names are up on the screen, so I don't think we need to go through roll call. In the packet that Sarah sent out, there were minutes from June 26th of 2024. Everyone's had a chance to review those. And if so, if there's any motion regarding approval of the minutes.
I'll make a motion to approve.
I'll second that.
And any discussion on the minutes? Any additions or deletions that need to be made? Okay, hearing none. All of those in favor of approving the minutes from June 26th of 2024 signify by saying aye.
Aye.
Aye. Any opposed? Okay, minutes are approved. Do we have any public comment?
No, we don't.
Okay. And we don't have any actions to be taken at this meeting. I think we went through plenty at the last minute meeting, so we can move on to our educational component, which is our manager, Chris Corpola, to talk about the opioid settlement funds.
Okay. All right, so to date, Dunn County, so let me take one tiny step back. So the original amounts of the settlements, it's not that they continue to change, but there are multiple layers of how the settlements are being divvied out. So there were the manufacturers, so there were the pharmaceutical companies, like you hear about the Sackler family and their wealth obtained from making opioids. So you have the pharmaceutical companies, the manufacturers who like actually made them, the distributors, and then the actual retailers. So there are like multiple layers of people that have touched and are being held accountable for opioids. And so all of those were separate parts of the settlement. So to date, Dunn County has received about a little over $400,000, between $400,000 and $450,000. And it's anticipated that when all is said and done, we will have received a little under $2 million, so $1.8-ish million. But those settlements are all like wonky. So like one company will say we're going to pay X amount of money over the next 6 years, but we're going to make 2 payments in year 1. The next company will say we're going to pay X amount of money in 18 years, and we're not going to pay the first payment until next year. I mean, it's just like they're all over the page. I think I have a spreadsheet where I've tracked them, and I think there's 7 or 8 different ways from those various entities in terms of how that money will be distributed. But it is definitely more front end loaded than it is on down. There's only, I think, only one of those settlements that goes out 18 years. So that money is currently sitting in a segregated account, which means also that because we can easily tell it's also earning money. So the county has something called we are part of something called the Government Improvement Pool, LGIP. And that is just a spot where we can hold our money kind of temporarily, pays more than a checking account or a money market account, pays sometimes the same, sometimes more, usually less in standard insurance times, pays less than long-term investments. But right now, because investments interest has been positive, it's earning about 5% interest, a little bit more. right now, but it hovers right around that 5% mark. So if you think about roughly the beginning of 2024, although I don't know that all $400,000 was in there in 2024, beginning of 2024, but if you had a full year in and you had 5% interest on 20,000 or on $400,000, you would earn $20,000 in interest as well. So all that is a long way of just saying that the money sitting is not necessarily a bad thing because it is earning interest, and that interest stays segregated to the opioid settlement money. That being said, Paula agreed to chair a group of individuals that included Sarah Benedict and the sheriff and the Menominee PD, and to help me, Paula,
Public health.
public health, to start to talk about what were the needs for which this money might be utilized. And there are parameters around its utilization, although they're relatively broad in the sense that it needs to be something utilized to mitigate the impact of the opioid crisis. So it can be used in treatment, it can be used in prevention, like early intervention, prevention can be used. And the more that you lean towards an evidence-based program that sort of is defined to impact drug use, particularly opioid use, sort of the more solid ground that you're going to be standing on as you spend that money. And so that group actually has met over the last roughly, I'll say 18 months. Looking at that, has created a hierarchical list of kind of needs, but I don't want to speak for that group, but was to say there are no current barn on fire emergencies that have overridden the benefit that money has had in just sitting for future use or emergency use versus funding something for a service right now. Now, it came close. I mean, it has come close in the sense of, like, for instance, our medication assistant treatment program with Shelley Jo Metzger and in the jail. That money was due to end at the end of September of this year. And then there might not have been more money, or there might not have been more money until the first of the year. There were some unknowns. So there was discussion about, like, that would be a potential use of opioid money to fill that gap in funding, or maybe even to fill that need going forward if there wasn't other funding. Turns out there was other funding, so that became less of a need. So right now, while there is a prioritization and a plan, there's been no, like I say, sort of emergency or emergent need to utilize or tap into that money quite yet. So that being said, there's also room then for that list to be altered should a need arise. Now, there's been some conversation about, is it just county specific, or does it go out? Do you engage the larger community in identifying the need? I would say I don't have strong feelings about that, but then I'm about to say, but I guess I do kind of strong feelings about that, just that at some point in time, there also become capacity issues around the people that are making decisions, and how do it takes a lot of time to pull in public input. And I think it could quickly make the playing field broad and make it difficult to sort of prioritize that. It would be a whole other project to say we're going to look at the broader community and funding to other kinds of things. And if you look at the prioritization list of things that the group came up with, we certainly have, a lot of internal need to be met as well. So at this point in time, there is no move forward to kind of broaden the net and ask for other parties to indicate if they would like money related to that. Part of that is that the Department of Human Services has a contract with Arbor Place, which funds any person needing treatment in Dunn County who doesn't have another ability to pay. So it's not like there were a lot of counties that didn't necessarily have money, particularly in residential treatment, and Dunn County always has had money. And so we don't need to use our opioid money to backfill for residential treatment. Now, there has been some discussion about, as there are potential individuals who, for whatever reason, can't go to our place, utilizing potentially some of that money for them to go elsewhere. That all became a bit more or a lot more complicated with the closing of LA Phillips. There's not really a great elsewhere convenient to go to for most people. So, so I think the summary is the money is there. It's earning interest. There is a prioritization list. The list is alterable if there is a new or an emergent need. At this point in time, and there are rules around how the money is spent, but it's really around the mitigation of the impact of opioid use. And Dunn County really has largely dodged a bullet when it comes to opioids. Now, it's not that there aren't any deaths, that there's no impact, that there's no legal impact. There's not none, but there are other areas that have been hit much harder than we have been hit. Our methamphetamine was certainly our drug of choice, has been our drug of choice over the last many years. Any specific questions about that?
Well, thanks, Chris, that was really thorough. So thank you very much for that background. I guess my only question is, have we used any funds yet? Or are they all still staying? So they're all still staying and collecting
They're all
interest?
just sitting there. Yep.
And then if there is a decision by this committee to use the funds, does it go to the county board then, or what's the process?
Well, we had a conversation with Chair McCullough about that. It's probably most reasonable that request would come through the department, through the Health and Human Services Board, and then on through. It'd be a budget adjustment. It would be essentially you taking the money from the opioid fund into whatever it was going to fund, and that would come through as a budget adjustment likely from Health and Human Services. Nothing magic about that. That just was a logical one, because either which way we'll have to go through a budget adjustment process.
Yeah, and that's at the board level, it's really just the top line numbers going through.
Looks like Paula, did you have something to share?
Yeah, I just wanted to share that we do have a meeting set up for Friday to bring the group back together and to really narrow down our prioritization list and potentially bring some items forward. And I also want to just concur with what Chris said. You know, when I talk to Arbor Place, our majority issues are methamphetamines and alcohol. I wish that I could use this to detox somebody, because just yesterday we talked about bringing somebody over to Green Bay because we lost our LA Phillips. And to detox somebody, going off alcohol could be deadly. And so that is, a priority for us and a high need, but we can't use these funds for that. So we just have to figure out where else we can go with them, just to concur with what Chris said. But we will continue meeting and put a list together that prioritizes and then take it through the committee.
I also think that I love the picture of us all sitting there in the galley. We look really good. But I also think that there's been consciousness with the kind of the planning group, but also just in general, when you have, in a sense, while it's ongoing because there will be payments for the next several years, but they're decreasing as time goes by. So you sort of have not one time, but limited time funding to not enter into the use, unless we're really pushed in that direction, the use of that money for an ongoing service. So, oh, we're going to develop a new, magical service, whatever that is, and it's going to cost $50,000 a year. But when the opioid money is gone, the opioids money's gone, and then in theory, you have staff or you have residents dependent on a service that can't be sustained. So I think it's been the thought of looking at it more as for short-term or immediate or emergent kind of needs versus ongoing. But again, none of that's etched in stone. You can make an argument, sometimes make a strong argument for utilizing it for something like Shelley Joe's position, where it had a lot of, it's had a lot of good impact, specifically with, and really its reach is much farther than opioids, but we can kind of keep it under that umbrella of opioids and fund, but we didn't need to do that.
Is there any ability to fund mental health related to opioid abuse, or is it has to be strictly for treatment?
It could be a co-occurring disorder, but you have to connect the two.
And
One thing that-
honestly, the issue on mental health often isn't funding. It's capacity of providers. It's finding people to deliver it. It isn't so much that people don't have, it's honestly kind of the same thing in substance use treatment. So when the state approved the use of your Medicaid card for residential treatment, the big glitch that most counties ran into is that they weren't funding residential treatment at all. So they didn't have a way to fund the room and board costs, which aren't covered by your Medicaid card. But Dunn County had been doing that. So now we pay the room and board costs for people who can't afford, who don't have another funding source, but Medicaid funds their treatment. And so that's, but even before that, after the Affordable Care Act was implemented, we really saw a significant reduction of the number of people who didn't have a funding resource for mental health or substance use. It's finding a provider. That is the hard part.
And we do have a grant now for that room and board. So Medicaid pays for the therapy. We have a grant for the room and board for opioid, not for meth, not for alcohol, but opioid. And then the other piece is the high-end costs. So, the Mendota, Winnebago stays, the detox, those things. But again, most of that is not opioid, it's other.
Well, I'd just like to add, I think one practicality is that the methamphetamines are contaminated with opioids. So from what I'm hearing from some of my Department of Justice partners is that we can really look at it with a broader lens when we're talking about the drugs being so cross-contaminated and with other things that we can really kind of take some of that broader look when we're looking at that poly drug use.
Which makes sense.
Yeah, yeah, absolutely makes sense. And then I'd just like to add that the state legislature does have a report published, and they'll continue to publish it on how counties are spending this money. And I'd be happy to send the link to people. This first report was most counties are just collecting the money, but there are reports, and it is public how counties are spending their money. That can give us ideas on future uses too.
One thing I'll mention that part of one of the qualifying things that this, or one of the, what do I say? Officer wellness or check-ins, mental health check-ins is a qualifying expense. And, I've advocated for earmarking some of this annually for a wellness check for officers. 30 sworn, if I didn't include my jail staff, that and it's not something that's covered by our EAP, otherwise I wouldn't even go this way, but wellness checks aren't covered by EAP, but follow-up therapy is, or counseling is. You know, at least $5,000 probably to get everybody a wellness check every year for mental health, and it's a qualifying expense for this.
And that would be one of those things where the cost is, I'm not for or against, don't know enough either, but that's a $5,000 at $5,000 a year, or even $10,000 a year, the money goes a long way. At $100,000 a year, you blow through it much more quickly. So, yeah, so those kinds of, that would be probably a good example of something that might be an ongoing expense, but is sustainable for quite some time.
Yeah, several sheriffs across the state are using it for their wellness checks for all their staff.
Well, I appreciate that there's a committee on it. I would just personally, I think a lot of decisions made for use of these funds would impact many of the individuals who work in this field. So if we just, as a CJCC, if we stay up to date on, if there's certain funds being used, or if there's a solidified prioritization list, that gets shared with this group, just so we're in the know. But I appreciate all the hard work, and sounds like it's not something that we're spending right away. And right now there's a good spot for earning interest. And so thank you, Chris, for that information. And thank you, Paula, for heading that committee. The next area on our agenda, does anyone else have more to add to that? Okay, sorry. And the next area on our agenda is the oversight area for the Treatment Opportunity Program. Just so you know, as part of back in the day, we used to have all kinds of committees where we'd have to get updates on this. And so when we restructured the CJCC, it was ruled that we would have sort of an educational component where we learn about the different groups that are grant funded and the different groups that impact all of our offices. And so that's why we have a little bit of educational components at every one of these executive and operations committee meetings. And so this week or this month, it's the top program. And so I'll turn it over to Janae.
Hey, good morning. All right. Well, I last presented to this group in October, so I'm just kind of going over some updates since then. Most of you are familiar with the TOP program, but again, designed to be a 9-month program, 3 basic components being case management, so meetings with me, treatment as an assessment, recommend services, and then drug and alcohol sobriety and testing. Interestingly, this year so far, about 46% of my individuals are being supervised at high risk, so meaning that they're meeting with me weekly and then testing weekly. Again, throughout the program, this can be increased or decreased at any time based on individual progress. So when I last presented in October, we went over what we were hoping to expand and enhance in 2024. Expansion, our program assistant is going to be working on a mailing to attorneys just with information. I would say this month, actually, I've gotten a lot more inquiries from out-of-county defense attorneys that are working on Dunn County cases, so that's been really good. We've opened up self-referrals. I've been doing question and answer sessions in the jail quarterly. And then enhancement of our contingency management program continues. We've increased basic needs assistance and incentives throughout the program as well. We've really partnered we've got like Goodwill vouchers, Hope Gospel vouchers. Our behavioral health officers have been amazing to work with throughout the program as well. So some 2024 program changes. I am still working on revising our contingency management program. Contingency management is a frequent testing program for stimulant use disorders, and then incentivizing negative drug tests. Those are twice a week testing for 12 weeks for individuals in the program. I've been working with Dr. Richard Rawson out of Vermont to just kind of go through and shore up some of our agreement stuff. And then work through some of our barriers like transportation, getting people here that frequently. Big thing this year was our Easy Justice case management system. We just rolled that out in April, but it really allows us to have better management of our individuals, having video check-ins, we can see locations, having them check in more frequently through that. And then we've got our program assistant, Jessica Fenner, that started with us. So she's able to meet with some of our individuals to provide more hands-on case management, housing applications, employment applications, again, just some of that individual assistance that I don't necessarily have the time for. So Jessica has been great with that. Some of the basics of the program. So we're looking to serve 90 individuals throughout a year. And at the end of June, we're at 41. So hoping to at least double that. 26 of those did carry over from 2023. Again, being a 9-month program, it's taking individuals between 6 to 13 months actually to complete the program. These numbers were also on the dashboard, but we've had 31 people referred, 15 new people this year, 9 graduated, 8 terminated, and then 5 generally discharged. General discharges can be things such as, say, DOC revocation, which are now going to be actually terminated. We changed that this year. I've had a couple of medical discharges, so just the inability to complete the program. When we're looking at referral sources, since we've opened up the self-referrals, 11 of those have been people, I'd say mostly Sandy meeting with them in the jail upon booking, and then they're interested in programming and are self-referring. Otherwise, district attorney's office, defense attorneys, and then DOC. I'd say the good thing with DOC referrals is that they are really quick turnarounds. So if someone gets referred, say today, they're starting within a couple of weeks. Whereas other referral sources, it takes a while to get through those court processes. So that's where on the bottom you can see right now I have 22 individuals that are eligible for programming, but they're still waiting for some of their agreements and court processes to get done. A few of the performance benchmarks that I am reporting out to the state. Individuals who are referred, getting their COMPASS assessment done. So those are individuals that Sandy and I are meeting with for intake. Within 30 days, we need to have 75% of them completed. We're at 87.5, so that was good. 90% of individuals having a case plan within 30 days of admission into the program. 100% of those are happening. And then 75% active receiving services, and we are at 100% of that too. So some of the benchmarks that the state is looking at, we are on track with those. Success rate so far this year, 53%. Again, some of that, it takes much longer to complete the program than it would to be terminated or discharged. So those take a bit longer to get, but overall program to date since 2018 is at 60%. Again, I already touched on, but completion time 6 to 13 months with the median average being about 6 months actually. Recidivism rates, those are also looking really good. So of the 125 program graduates, after 1 year, we're at 17%, 2 year, 21%, and then the 3 year at 28%. As of 2022, it looked like the national average for prison recidivism risk at 3 year is 68%. So 40% reduction looking in programming here. The state is actually looking at moving these measures to 6, 12, and 18 months, but as of right now, they remain at 1, 2, and 3 years. And that is kind of my brief overview and update there, but any questions for me on programming or stats?
No,
Janae,
other
would-
than, I would just say, I think that those data points look amazing.
Absolutely. And Janae, would you want to just give a touch on what you're doing as far as your leadership on the state level with the state CJCC work groups?
Yep, so I recently this year joined the Diversion Performance Standards Work Group. So that's where some of those performance benchmarks come in. looking statewide to have just some kind of gold standards of what sites can look for to have, comparison throughout the state. So we have been revising a document that's been in the works for many years. I'm also on a calculation work group now, so we are getting closer and hoping to release that document for the state to have some guidelines by the end of this year.
Great, yeah. We're one of the few states that really have an established diversion program. So Janae's been fantastic in helping out with the Department of Justice and others really, and other sites. There's just a few other sites that are really working to put these standards and performance measures in place. So again, just really reflecting well on Dunn County and the work we're doing.
Okay, any other questions for Janae? Doesn't sound like it, so thank you, Janae. Next item on the agenda is local challenges, collaborations, and priorities. And I think I asked Sarah or when we planned this to put on domestic violence and so sort of my own selfish reasons, just so you're aware, kind of the organization in the district attorney's office is, each attorney is assigned a specific case type. And so domestic violence is not mine. Lucaris does it. But we rotate who's on intake. And so when you're on intake, you get to see kind of all the different cases that are going on in the office. And maybe it was just a rough week of intake, but it seemed like there was sort of a larger number of domestic violence and repeat domestic violent offenders. And I feel like as a CJCC, we talk a lot about drugs and the TOP program and treatment court and drug court and MAT. And I just wanted to bring up, domestic violence and the large statistics regarding, extreme violence and homicides associated with domestic violence. My understanding is there's not a great evidence-based system to treat domestic offenders. And so I think we use the SAFE program, and somewhat maybe Sarah or Michelle can help me as to who that is. She was part of DOC that puts it on.
Sharice Nielsen, the former supervisor, field supervisor.
Yep. And I mean, for Sharice, I think her availability is quite limited for a lot of our people. So there seems to be quite a wait list for Sharice. We have been referring a lot of our DV individuals to the St. Croix Justice Program. They do an assessment, and for the most part, our people can receive some sort of counseling through them. There has been a couple individuals who were evaluated, and St. Croix said that they didn't have the ability to treat those people, that they maybe needed a higher level of program. So in that case, we go back to, what we have, and we try to work with Sharice or other programs, but we just haven't really had a lot of luck with the wait lists and such. So the St. Croix Justice Program has been a huge help for us in that sense. But we do still periodically refer to Sharice.
So how long is that program, Michelle?
The St. Croix one?
Yeah.
I think it depends on their level. When they go through and do the assessment, I think it depends on what level they're set at. And I think it goes like if you can do online stuff or if you have to go in person. But I'm not sure the exact length. I can ask some of the agents. For some reason, I feel like it's varied between individuals.
I have an individual going there right now, actually, for service that's in their SAFE program, Stop Abuse for Individuals and Families. And their men's group is 6 weeks long, twice a week. So 12 sessions.
So it's the same program, SAFE.
It's not actually, it's SAIF in St.
Oh.
Croix. Yep.
Okay.
Stop Abuse for Individuals and Families is their program, and then Sharice runs, I can't remember what her acronyms are, but yep, the St. Croix one is, the general one is the 12 sessions, but like Michelle said, there are varying services there also.
Mhm.
And then the SAFE program that Sharice does, I know that's really long. I just don't, does anyone know how many weeks that is?
I can look for it. It's hard to tell. Sometimes it gets drawn out longer because Sharice goes on vacation. So it's, I'll look and see if I can find the details of it. I don't believe she's a part of the DOC contract anymore. So the people that we send to her, they have to pay for on their own out of pocket.
We do have Sharice doing the SAFE program in the jail for people, and that's a grant-funded contract that we have. I don't know how often that's going on, at least once a year they have a session. But I know what Sharice is doing is a evidence-based program
Mhm.
through the change companies. I have no knowledge of what the other SAFE program is in St. Croix and what they're utilizing, but I think the general challenge out there is that there really isn't just a one magic program when we're talking about DV and effectiveness. I think this is a field that continues to change and evolve, and some of that traditional Duluth model in delivering domestic violence treatment is they're going away from that. So I think this is an important need that we see. You know, Andre talked about how she's seeing it in the court. I think we know that the statistics of violence related to domestic violence, and then we are somewhat in a landscape that doesn't have the services that people can really benefit from. So that's why we're having to do things that are virtual with Sharice or having to go out of county to get those services.
So I'm just looking at what her program looked like when she was with DOC, and the Stopping Abuse for Everyone is a 26 lesson program that can be expanded to 52 lessons for people who may be a higher risk. So it is pretty lengthy. And if that's, the same program that she's doing at the jail, I'm guessing she probably goes there at least once a week.
Yeah, it's all virtual for the SAFE program. Yep. And we do have, I know, a family treatment court participant that's currently taking part in that, and really good feedback from that DV.
And I know law enforcement is still doing their lethality assessments and contacting the bridge, and I think that's helpful, at least for my office, for knowing when to be requesting no contact orders. Sheriff Chris, anything to you to add regarding domestic violence that you think we should be doing, or I had Maria here with me as well from Victim Witness, just to talk about what safety planning entails when a victim wants a no contact amended, but anything on the law enforcement end that we should be looking at or doing a better job of?
The one thing, I think Judge Peterson has kind of changed how we're applying bonds, no contact orders on bonds. That now we're back to running it past the judges or the on-call judge. Years past, if the victim wanted the 72-hour no contact order enforced, we automatically added a no contact on the bond if they paid a cash bail to get out of jail. But that's back when that violation of a 72-hour no contact was a forfeiture violation only. Now it's a criminal violation, so I don't know how big the need is to keep that, no contact on the bond. At least we can go back and arrest them for a criminal violation if they violate the 72-hour no contact now. We got to clarify kind of that process with the judges.
I would say, speaking off the lethality assessment that we're still doing, our department's still doing the domestic violence response team. So we'll go out and make contact with the victim within 72 hours of a domestic violence incident, where they do screen in on the lethality assessment. And we usually try and do that with the bridge, with an advocate from the bridge. We haven't been terribly successful, but I will say that some have taken the services, and I mean, obviously they're at a higher risk for serious injury or even death. So even if it helps a couple along the way, I consider it worthwhile. But I agree with you, Andrea. We've seen a big dip in domestic violence cases for a while, and then all of a sudden in the last 2 weeks, we've had quite a few. Unknown why, but some of them pretty violent too. So but yeah, we're still cruising along with the domestic violence response team. We've been doing that for probably 7 or 8 years, if I had to guess. So.
And does the membership of which officers, is there a certain officer, or is it who takes the call that's part of the domestic violence team?
Unfortunately, because of turnover, we've had to put different officers in those roles. Right now, I think we have 3 that are still doing it, but we're opening it up to, as some of our younger people get more experience, we're opening it up to them too. But we try and choose those officers that are just really exceptional with dealing with victims and getting some rapport with them when we're on scene initially, and then to keep that rapport moving forward. I would say historically, Bridge to Hope's probably had a little bit better luck staying in contact with some of our victims than maybe law enforcement has. But we try at least 3 follow-ups with the victim each time. That's best practice of what we should be doing. And like I said, we haven't been super successful with staying connected with those victims, but if we can at least connect with a couple of them and get them some services, it's better than nothing. So.
Thanks. Judges, anything from you regarding, the bonds? I know sometimes we see multiple cases in different branches and different no contacts depending on the case. Is there anything that you could see or in your view that we should be doing differently to help with that?
Well, I'll say,
Thoughts?
go ahead. Judge Peterson, go ahead.
All right. Well, no, I can't think of anything specific, but just to address the no contacts, I think there may have been some misunderstanding about how things, were operating. And, right now we just want to make sure, if an officer would like to have a no contact as a condition of bond, they should call the on-call duty judge or backup. And that way it's an enforceable no contact, because otherwise, I think that was a while back, quite a few years ago. I think a chief judge had said that, I think when Judge Needham was the chief judge, that it has to be specifically judicially authorized in order for there to be a no contact provision on the bond. And so we just want to make sure that, we're doing it correctly. But yeah, there's just, every case is a little bit different, and so I don't know how to address that generally, unless anyone has any questions, general questions, but not about specific cases.
Yeah,
I would just say,
go ahead.
all right.
Judge Wagner.
So I would just say it doesn't happen, fortunately, too often, but more recently, I know we've had an individual or individuals from time to time that post and then soon thereafter violate, either at the victim's urging or on their own. And then we have modifications on certain cases that are before certain judges, and there's multiple cases open amongst all 3 branches. And I guess I would just say, really, just to make sure when we're addressing those bond modifications, that everyone's aware of the fact there's other bonds and other cases and other branches, because I know recently we had an individual with multiple cases, and one bond allowed some limited communication, the other one didn't. And it's just something that gets to be really confusing for everyone involved. I think first off for the defendant, and then law enforcement, and then the judges as well, when we're trying to address those. So again, fortunately, it doesn't happen too often, but I know just recently an individual with multiple branches that has been involved with a lot of allegations and same victim, and the victim changes her mind, I think, sometimes if she wants contact or not, and to what extent the contact's going to be there. And it just was kind of a mess to try to sort out a little bit. But in any event,
And so then, regarding the no contact orders, frequently, especially in these cases, the victim might want the no contact originally, but as the case progresses, they want a no contact removed, or they want no abusive contacts, or contact through telephone or email. And so I was just going to turn it over to Maria just to discuss kind of the process used when a victim on a case wants a no contact amended.
Yeah, so when a victim wants no contact amended to either no abusive contact or just to have electronic contact only, we go through a process. We contact Bridge to Hope and set up a meeting with them. Usually it's Jamie Dardine, who is the legal advocate over there, that comes. And we set up a meeting with Bridge to Hope and the victim, and they go through safety planning and talk about a handful of things in the incident, and kind of look at the whole case and everything, and even past history, and kind of just let them talk to them. After they meet with Bridge to Hope, we go through the bond form with the victim to see if they're still wanting to amend bond. There's been times where safety planning has been done, they want to go forward with it, and after safety planning is done, they change their mind and decide not to go forward, which is kind of nice. Obviously the safety planning is working, and things are getting done thoroughly there. Once the bond form is signed, the victim wants to go forward with amending the no contact order. We send it over to the prosecutor on the case. They'll either object or be fine with amending it, and then we then send it to the defense attorney on the case to see if they have any objection. There's been times where we've had defense attorneys say that the defendant no longer wants to have contact with the victim, so they want to keep it in place. It's pretty rare that happens, but it has a few times. And then we e-file it with the court. There's been times where the judge will just approve or deny the request. And then a lot of times they'll request a bond hearing. And then we contact the victim and let them know if they want to speak at the bond hearing and if they have input, and kind of go from there. So unfortunately, we've had a lot of cases where victims have many different cases with the same defendant, and so there's there's a lot of charges and a lot of pending cases that they always want to amend after a week or two to no abusive contact. We do see that quite a bit, and charges keep coming in, or there's violations in the no abusive contacts or orders, or other specific orders. So unfortunately, we do see a lot of the same people. I can't think.
So I think sometimes the complaint from victims on a case is it's not immediate. So usually when they call the office, they want that no contact dropped, and they want it dropped immediately. And so it does take a little bit of time to schedule that safety planning, but we do think it's certainly important, especially if there's other kids in the house, to make sure that there's a plan in place for them, that if there's firearms in the home, that those are being addressed before my office, or at least, makes a decision on whether we object or not object, and then before it goes to the defense attorney and to the court. So sometimes it does take a little bit of time, but I also wanted to note sometimes there are some victims who want to remain completely anonymous, that do not want to be called out in court, do not want to be seen in court, don't want, so, unless the state says, the victim wants to speak, usually I think it's best to maintain their privacy, that they're not being called out in court. Is this the victim here? And, if they want to make a statement, we'll say that the victim is here and want to make a statement, but we just also need to make sure with Marcy's Law that their privacy is being protected. Any questions or concerns about that process? Okay. So we kind of threw that in there as a local challenge, collaboration, priority. I think it might be something I think there's a need for programming, but something to kind of keep on the forefront since we've seen that increase. As far as moving into,
Oh, Andrea, if I could just, I did a little bit of research, and if I can just share real briefly some factors that go into the success of no contact order.
Sure.
Just real brief here. So I'm going to try to share my screen, share, and do you see initial research screen? Yep. Okay, good. I don't see what you see, so it's kind of different when you're presenting. So so really briefly kind of looking into the effectiveness, because one of the questions was really are no contact orders effective? And this is really just to start the conversation and get other questions and things that come. But overall, there's a number of factors that can go into the success of restraining orders or no contact orders. The effectiveness is widely variable. So it can be up to 15% successful, up to 85% successful, depending on the studies. So, rule of thumb can be, 50-50. These orders can be successful about half of the time. But some of the common factors that go into the success would be the past behaviors of the alleged perpetrator. So if there has, people that follow rules will follow the rules of a no contact order. But if not everybody's a rule follower. So that's one thing to take into account. If somebody's had a past failure on a no contact order, they're more likely to have a contact and violate that order again. If they don't care about the repercussions, if they don't care about being arrested, they don't care about the court process, they don't care about their own life or others, they're less likely to follow that no contact order. The second point here, victim reporting of violations. It's super important that every violation get reported to police, and it's important that police enforce and follow up on those reports. So it said that a lot of victims are vigilant and they report every contact. Some don't report any contact, but there can be a disconnect from what law enforcement officials know as far as what's going on with the contact and versus what's actually going on. So it's important for police to respond and to write up reports when there's no contact violations. Sometimes there might not be reports written if there is not the suspect's not on scene or they're not present, but it's really important to create that record. Some restraining orders can make the situations worse. So if it is a dormant situation that is no longer volatile, it can, by putting a no contact order in place, it can create some anger and engagement that was already at rest. It can reignite that, which can create new challenges. And then the last thing is it can create a false sense of security. So we heard about the safety planning. That's super important. So if a victim just thinks that if there's a no contact in place, that the police are there, they're watching, they're looking out for this perpetrator, that's not necessarily the reality of it. So it's super important that there's more things beyond that no contact if it's put in place. But it's certainly something that can be an initial step, but it is not the step that is going to keep people safe overall. So just some initial research but it sounds like there's more to be said on this topic. I also just want to highlight that Sandy Frigo is leading up a small work group of kind of picking up where we left off with the domestic violence and the battered women's project, where we mapped and really looked at that firearm surrender process. So she is leading up that small group and getting them together and really looking at recommendations as far as what are some things that we can do to shore up that area of domestic violence and supporting victims, but then also how we can use our $5,000 that we have donated from the Battered Women's Justice Project. So thank you.
Okay, great, Sarah. Also, Maria just mentioned too that a lot of victims do have confusion when they get a restraining order and then a no contact order, and then the no contact order is amended, that they don't understand the restraining order needs to be amended as well. So just for time's sake, we only have about 3 minutes left. I'm just going to whip through the rest of the agenda if that's okay with everyone. Number 9 is emergency trends and opportunities. Judge Meyer sent out or shared with us the summit on domestic violence and child welfare, October 24th and 25th. And we're hoping we'll be able to send a team from Dunn County on that. So you are able to send staff, please do so. August 8th is the next CJCC meeting. Does anyone have any input that they want to share as to what to address at that meeting? Okay, hearing none, I'm going to move on, but always feel free to email me or Sarah or Judge Meyer if there's anything that you think that should be added. I don't think we have time for agency reports. Sarah, your staff report is in writing. Anything you wanted to add to that?
Just wanted to highlight that the kaleidoscope utilization report is also attached, and some of our grant funding goes to extend the hours, and you can see from their stats that those extended hours have had a huge impact on the number of people that have come through the doors down there. So just really trying to kind of expand the reach and share the good report there.
Great. And then our next meeting for quarterly is August 8th, or that's the large meeting. And then our, again, our executive and operations committee, the smaller one on Teams, is September 11th at 11 a.m. Glad to see all of our judges were able to get on Teams. Good job. I know it's harder with the state computers. So can I get a motion to adjourn?
So moved.
And a second?
Second.
Okay, all those in favor of adjourning signify by saying aye.
Aye.
All right.
Aye. Anyone opposed since I went really fast through the rest? Okay, hearing none, we will adjourn. Thank you all. Have a good day.
Thank you.